car insurance.
You're listening to Silver Moments with Dr. Marsha Baltimore.
Hello, everyone. Someone has called us on our line, 800-336-2225, and we're going to take that call for you now.
Hello?
Hello.
Yes. I have a question for you. I have a living trust, but one of my concerns is how often do I need to actually update it, or is it something I just did once and don't have to worry about it again?
That's a frequently asked question for which I give frequently different answers depending on who I'm talking to and the time that I'm talking to them. With the, the uncertainty of the tax code right now, because the $5 million exemption that you have to, for estate taxes this year and next year goes down to $1 million in 2013 under the current law. You need to have your trust flexible enough to handle all these situations. There are some trusts that do handle them. Also, if you've had, in terms of change in circumstances, if you've been divorced or you just got married or you have new kids or you want to disown somebody, all those things require an update of your trust and all your estate planning documents. I've seen trusts that were written 15, 20 years ago, and they're perfectly fine today. I've seen trusts written 3 years ago that are worthless because they went to what we call a trust mill, and they just fill out a generic form, and they don't ask the questions that you need to have answered, like do you really want everything divided equally among the children? At what age do you want them to have it? What if circumstance A occurs as opposed to circumstance B? They're not fine-tuned. And then there are some that just flat out make mistakes. So if you're comfortable with the lawyer who drafted your trust, you should contact that lawyer and ask him or her, do I need to have it updated? And they'll tell you the truth.
I see.
Okay. I don't know.
Or you
your
can call
circumstances.
Mr. Katz.
Yeah. You
At
can always call me.
571-2727.
Yeah. I'm sorry, Marsha.
I'm just joking.
Yeah. I don't know your circumstances, so I don't know if it's time to review them. But typically when people come see me, 9 times out of 10, we got to fix them.
I see. So naturally a situation would be in the case of you sold a piece of property and bought another piece. Well, then if you didn't do, like you mentioned earlier about the deed and that type of thing, then that wouldn't be included in the trust, and that could be an area where you'd forget about, and then you'd have a problem. Is that correct?
You'll have a problem if you have a piece of property that is not titled in the name of the trust. In other words, if you had a rental property that was named Charles Jones, owner of the rental property, and you die and you had a trust, well, you're going to have to probate that property to put it into your trust.
See.
However, all it takes is a deed. It's called a trust transfer deed. You say, I, Charles Jones, transfer to Charles Jones, trustee of the trust. Now, typically when we set up estate plans, we give the client what's called a trustee certification or certification of trust, which is used when you go to a financial institution, for instance, to set up a brokerage account, a big account. It tells you exactly what language to put on the signature card. And it also contains the language that you would put on the deed. So it says if you take title to any assets, you would take it as Charles Jones, trustee of the Charles Jones Trust, dated such and such date. That's how you would take title. And that would solve the problem. You don't have to redo the trust if the dispositive portions of the trust, meaning who gets what, when, and where, stay the same. You'd only have to in that case, you don't need it unless there's some tax issues that need to be addressed.
I see.
Ownership of assets, typically nowadays we do not list the assets as an exhibit to the trust because you're always buying and selling them. We just make sure that you remember to put your assets in the trust. That grant and assignment I spoke about at the end of the last segment also says it relates to real estate, and that's been upheld, but it's a lot cleaner if you don't have to litigate. I had a case once where a man died and his trust gave everything to his brother. He had over $1 million in a brokerage account, but he had never put the brokerage account in the name of the trust. But under the Hegstead doctrine, that case I talked about, he had done a one-paragraph assignment. Just says, I give all my assets to my trust.
I see.
And I convinced the legal department of the brokerage account that we didn't have to probate it. And so my client got the $1 million plus in his name without having to litigate or probate it or anything. And of course, he kept the money in that account also. The same thing happened with a man won a lottery, and he had what the equivalent of a structured settlement. Every 6 months, he got $350,000.
Wow.
Yeah, it was a lot of money. And he told me when he came in that it was payable to the trust, not to him, and I believed him. Of course, after he died, his wife says they want us to probate it, which would have made me tens of thousands of dollars. But I convinced them also, for a small pittance of a fee, I may add, to just give it to the widow outright. And so she sends me New Year's cards every year. But that's how that would work. I would advise you look at your assets, see how they're titled, and fix it.
Okay, because this is just amazing to me. I mean, this is just an amazing program, because now I'm learning all kinds of information. And to me, the biggest thing that comes out is you have to have an attorney do this type of stuff.
Good for you. You picked it up. Good for you.
That type of thing.
Yeah.
That
Anything
number
else, Charles,
again
or
for
is that
this
it?
attorney is 310-571-2727. Can't do any better than this gentleman.
Thank you very much for this. This is very, very good.
His name is Mr.
Thank you.
Solomon Katz. Shalom Katz, K-A-T-Z.
How do you feel? Where are your views on what you're hearing? Give us a call and share them with us